Good morning, Your Honor. Frank Delagrange on behalf of Mr. J. Goldstein for the appellant. And I'd like to reserve 5 minutes for rebuttal.
All right.
Judge, I'm here today on behalf of Mr. Goldstein, writing on the heels of the Barnhill decision, which we supplemented the record last week and provided the court with the Barnhill decision, which I'm sure the court is well aware of. That opinion was rendered 12 days ago on a case that's strikingly similar to Mr. Goldstein's case. This particular case, Mr. Goldstein's was heard by the same judge as the judge in Barnhill. The sentence in Barnhill was rendered 7 months prior to the sentence in Mr. Goldstein's case. Both cases involved child pornography. Mr. Barnhill's case only had 20 counts, where Mr. Goldstein's case had 100 counts of child pornography, but they both relied on the same statute for downward departure, which is Florida Statute 921.0026, subsection 2D, which is dealing with a mental disorder not related to substance abuse and amenability of treatment. Both in Barnhill and in Goldstein, they relied on the evaluations done by psychologists. In Mr. Barnhill's case, it was Dr. Burston, and in Mr. Goldstein's case, it was Dr. Heimoff. They both came back with conclusions that they presented minimal risk of reoffending. They were all amenable to treatment. They had all had polygraph exams, which showed that they had had no contact with children whatsoever. And in the Goldstein case, the psychological evaluation, as it was in the Barnhill case, was not contested. The only comments that the state made at the conclusion of the state's argument was with regards to a penal blythos, I always say that wrong. Blythosmograph.
I can't pronounce it either. But
Okay, well then we're in good company, Judge. And the state asked the court to dismiss that because in that particular test that there wasn't any child pornography used in that evaluation. Also, Mr. Goldstein had admitted to the psychologist of masturbating to child pornography. And same as in the Barnhill case, the state said that there's no way we can predict whether or not this individual will reoffend. Also, very similar in the pronouncement of sentence in both of the cases, Judge Thorpe in both cases said the same thing, that he sees these cases every day because he's the judge that handles sex offender cases in Hillsborough County. And he also discussed about the fact that none of these people that commit this particular crime of child pornography have any prior records, and that they have a dark side to them. He also discussed in his pronouncement of sentence with regards to jurors that every time he's required to pick a jury in a sex offense type case, that numerous jurors, anywhere from 8 to 10 jurors, approach the bench and request that they be excused from jury duty because they can't be fair and impartial, because at one time in their life either they've been abused or somebody that they know has been abused. And in the Goldstein case, when the judge pronounced sentence, he said that he was not willing to take a risk at some point in time. People with a proclivity for child porn at some point in time would offend by actually abusing a child. So what the judge did in this particular case is pretty much that he is across the board decided that anybody charged with the crime of child pornography is not something that he would consider giving probation to or a lenient sentence, even though in the case of Mr. Goldstein, he was looking at 112 years and he received a sentence of 20 years.
Let me ask you a question, Mr. Delagrange. It's my understanding of the facts of this case that there was almost not an agreed upon, but didn't the state and defense pretty much agree to maybe, was it a much lower sentence that the judge ended up doing?
Yes, ma'am. On March 11th of 2013, prior to the plea that was entered on April 23rd, the state and the defense had gone into lengthy plea negotiations where the state had agreed to cap Mr. Goldstein's sentence at 10 years. And the state actually gave several reasons why they felt in Mr. Goldstein's situation that was appropriate. When he appeared before the judge on March 11th of 2013, the state went through the enumerated reasons for their reason for giving a reduced sentence. And at the conclusion of that, there was a discussion with the judge, and the judge said that he would not accept the plea negotiation and that they could either set the case for trial or enter an open plea.
Okay. And in this case, when the psychological evaluation, all that was before the court prior to him pronouncing sentence?
That's correct. The psychological evaluation was done in June of 2012, and I believe it was furnished to the court sometime after August.
And did the state provide any type of controversion to that, anything that would contravene the psychological evaluation?
No, ma'am.
Okay, so basically it was uncontroverted. That was the evidence before the court prior to him pronouncing
Correct.
sentence. All right. Thank you.
Your Honors, based upon the similarity in Mr. Goldstein's case with the Barnhill decision, which you've recently rendered an en banc decision, I'm asking the court to reverse the sentence that was previously imposed by Judge Thorpe of 20 years and to remand the case back to the court, to the trial court, to be sentenced by a different judge. Judge Thorpe's sentence and the way he arrived at that sentence violated due process to Mr. Goldstein. It also committed fundamental error, and that he didn't consider any of the sentencing options or the legally or the statutorily authorized sentencing options available to the court, and he did not review any of the totality of the circumstances that were available to him.
Let me ask you a couple questions, if I could, sir. First of all, in this case, it was a downward departure that was agreed to by the state, so they told the judge before he imposed the sentence that's on appeal that he didn't have to make written findings, right?
Well, when that discussion was had on the record, the sentence yet not have been imposed.
Right, but the point is that the state said to Judge Thorpe, in response to his question, well, it was kind of strange. He said, are you guys going to appeal me? And they finally said no. And the implication I got was, well, they'd already agreed to depart to 10, so they weren't going to require him to make written findings.
That's correct. They did say so.
So now, if Judge Thorpe had just kept his mouth shut and simply said, Mr. Goldstein, here's your sentence, would we be having this conversation?
No, Judge, because once again, the way he arrived at his ruling.
Okay, so that's the first, and I'm trying not to be rude to you because I'm really not, so I apologize if you're getting that impression.
No, sir.
Okay, so we wouldn't have that conversation if he just said, Mr. Goldstein, here's your sentence. 15 followed by 5 stacked on up. Now, if he had said, I have read Dr. Imhoff's report, and I don't know that I agree with everything, and I've considered Mr. Goldstein's evidence, and here's what I think the appropriate sentence would be, and gives him the departure that he gave, would we be having this discussion?
If he had thoroughly weighed all of the factors, the aggravating as well as the mitigating factors, and pronounced that in a sentence, no.
Okay. So if I understand your position in this case is that he essentially seems to have categorized Mr. Goldstein along with all of the other sex offender cases that he's had experience with.
I think the judge, I think, has reached the conclusion that anybody involved in child pornography is a pedophile.
Well, I don't recall him saying exactly that, but maybe I didn't have all of the record. I don't know.
That's his feelings are that because child abuse is required in order to produce child pornography, that people that are attracted to child pornography at some point in time will at one time or another touch a child, and that was his main concern.
Okay. Now, the impression I was left with by reading his statements, both in this case and in Barnhill, was that this was based on all of the experience he'd had with these kinds of cases over a period of time. It wasn't clear to me exactly how long, but somewhere in that neighborhood. So is it your position that the judge can't use that experience that he's had over several cases to factor into his sentencing?
Judge, we all bring our life experiences into anything that we do in life. However, in this particular case, I feel that the judge has become jaded because of the time that he spent as a sex offender judge hearing strictly sex offense cases, that he can no longer be fair and impartial.
Okay. All right. Thank you.
Thank you.
Okay, thank you.
I have nothing further. Thank you.
Okay.
May it please the Court. Cerise Taylor on behalf of the state of Florida. Your Honors, this is not Barnhill. Although the law in Barnhill is applicable in this case, it's controlling in this case, the facts of this case, the way the sentence was rendered, distinguish it from Barnhill for multiple reasons. First of all, in making his ruling, Judge Tharp expressly referenced Dr. Imhoff's report and talked about it and talked about its credibility and referenced it in terms of what Dr. Imhoff had to say, but also had before the trial judge the argument from the state, which just prior to the court's ruling, the state noted that what we're talking about here is punishment for the crime that was actually committed, which is 100 counts of possession of child pornography. And so that is what the state's goal and intention was to receive punishment for that crime. So in beginning his ruling, the judge talks about Dr. Imhoff's conclusions, and also the state in its argument noted that because child pornography was not used in testing his sexual excitement, that had to weigh against Dr. Imhoff's report. Secondarily, you have the nature of the pictures. Judge Tharp references the fact that there was a picture that was bondage. We have multiple pictures and videos, different boys and girls, different combinations. And so he does reference the photographs in making his ruling. And then we have his admissions that he used these photographs for sexual gratification. And so Judge Tharp references these factors in making his ruling. And I think what's really important here, Barnhill doesn't give us a clear picture, but in this case we have a picture of what the courtroom atmosphere was like.
But how about the statements, though? I mean, if you read Judge Tharp's explanation, he went on and on and on, and he gave the impression that he was not about in any way, well, two things. The fact that he rejected the 10-year, that perhaps adds a factor. And then some of the comments that he made.
Okay.
I think Barnhill is right on point, and I think what you're hearing your argument, that means we have to recede from Barnhill, we have to reject Barnhill.
No, Your Honor, no, I'm not suggesting that at all. Paul, I don't mean to interrupt you, but no, I'm not suggesting that at all. What I'm saying is that the focus in Barnhill was, did the court follow the two-step process? Did it determine as a matter of law whether it could depart, and then whether as a matter of fact if it should depart? And that was the test that this court found the judge did not apply in Barnhill. But what makes our case distinct is that Mr. Goldstein, by all accounts, aside from his criminal act, was a person who was beneficial to the community and had made a lot of friends and mentored children and that kind of thing. And so they had a packed courtroom of 17 people who testified to his character. Critically, when you look at that testimony, you have at least 4 to 5 people saying they were shocked and surprised and disgusted, and it was aberrant behavior, but yet and still they were on his side and asked for mercy. When Judge Tharp makes his ruling, he expressly indicates, this is not for you lawyers, this is not for you Mr. Goldstein, this is for the audience, so the audience can understand why it is the court's it is necessary for the court to impose a criminal sentence of prison, because you have to understand the context of this case was they had this plea deal that they had brokered for 10 years, which the judge rejected and said plea open. They then go into the sentencing hearing and ask for probation. So knowing that the court had rejected the 10 years, they come in and ask for probation. But we still have 100 counts that were charged, 300 counts that were seized, of criminal criminally produced material. And so what Judge Tharp is trying to say to the jury is, I understand that he's your close friend, your mentor, that he never actually harmed you, which is what Dr. Imhoff's report really is talking about. Is he going to go out and commit sexual abuse against children? But the question is, and the crime is, possession of sexual material, of sexual pornography depicting children. And so what Judge Tharp is saying is, first of all, this is not a victimless crime. Even though he didn't touch any children, children were raped and harmed in the creation of this material, and that criminality must be addressed. And possessing that material is a criminal act that must be addressed. Secondarily, the court is saying, I understand that you're saying you're shocked and appalled. I understand. I'm on this bench every day, and I understand that there's a dark side, and that's where this dark side testimony arises. We don't have a context in Barnhill for why Judge Tharp said what he said, and that is the reason.
Isn't the problem here that the comments seem to suggest that the court has predetermined in advance that for this type of crime there is a particular length of sentence that's going to be imposed regardless of anything else, any evidence, any expert findings, any particular circumstances.
I think
and that, you know, the judge is just not going to take those things into account and is going to impose the same kind of sentence no matter what gets presented. I mean, isn't that the real problem here?
I think two things. First of all, if that was really true, he could have imposed the CPC sentence, 112 years. We wouldn't have this problem. We wouldn't be here, as Judge Jenkins said, if he had imposed the actual criminal sentence imposed and mandated by the state of Florida. We wouldn't be here because we'd have a 112-year sentence. So he did, in fact, show mercy. He did, in fact, downward depart. It's just not enough of a downward departure to satisfy the appellant. But also, when you look at the sentence, if he had a rote general method that he applied. And the cases that we argued about in the brief show this. In the one case where they reject youthful offender sentence and the judge says, I just don't do youthful offender. In the other case where the judge says, whatever the number is, I always round up. We don't have statements from Judge Tharp like that.
Well,
and the Barnhill...
If I may, Ms. Dale, I guess
Yes.
I'm troubled by that, because if you look, and I just pulled up the transcript right now to follow up with what Judge Wallace said, he basically rejects the psychology report, and then here's the quote, and I know from my experience in sitting in this courtroom day in, day out. So he's basically saying, I'm rejecting everything, and I am now, this is what I am. Isn't that, in a way, follow up what Judge Wallace said, that he has in his mind a certain preconceived notion as the type of sentence that will be appropriate, because these cases, they're all fall within that category. That's what's troublesome.
Again, obviously it finally rests with this court to decide how to interpret Judge Tharp's comments. It's the state's position that because he referenced the report, it reflects consideration and rejection, and that is something within his authority, to consider the credibility of a psychologist who's been before him before, the context of what was tested with regard to the subject, and the conclusions that were reached, and it was in his authority to reject those. The state does not believe that that suggests that he was following a predetermined pattern. We don't have identical sentences in Barnhill and in this case. What we have in this case is a 1/5 of a sentence.
They're both in a 20-year range, though.
That is true. But the proportionality is important. In Barnhill, he was seeking 5, he got 20. In our case, he had a minimum of 112 and he got 20. And so I think when we're looking at the question of fundamental error, which is...
I mean, 112, I mean, the man's, what, 50
Sure.
years old? 112 years, what difference does it make?
Well, with all due respect, Your Honor, that's the basis of Miller and Graham, this idea that how many years is too many years. And so this court does not base a decision on, you know, I'm an old person and therefore my criminality should be ameliorated by the number of years I have to spend in prison. Maybe someday that will be a sentencing factor, but for right now, what was before the court was what crimes were committed, what criminality does the state of Florida attach to those crimes, and what kind of mercy, if any, because you're not entitled to downward departure. There was no entitlement to this mercy, but it was given, and I don't believe, and this court will correct me if I'm wrong, that it is outside of the court's authority, the sentencing court's authority, to consider overall factors known in the community, to consider their experience in making their decisions.
But he went beyond that, Ms. Taylor, and he made a comment in comparing the Barnhill with this one, and he has in our case here, quote, "I'm not going to take the risk of this child for a child pornographer to go out and touch a child." And if you look at the Barnhill case, same thing, is that basically it says something about the touching. I mean, he has in his mind a certain preconceived notion, and where's the due process? In his mind, he thinks it's no matter what it is that you're going to bring it to his attention, no, these type of cases all categorized in a certain thing. This is what's troublesome about that. I agree with you that the court, as a former circuit judge, I could reject whatever information was provided before me, but for him to make statements like this that are clearly beyond, that clearly indicate that he has in his mind a certain preconceived idea, that's what makes it problematic.
And the thing that I go back to is the posture of the courtroom in this case, and I do not believe that Barnhill references the posture of the courtroom in that case. But the judge, I believe, is trying to put into context the fact that where they've been asking for mercy, that he knows that they're going to find 20 years to not be merciful. That these people who want him on the street right now are going to find that the court was being not merciful in applying any kind of criminal prison sentence. And so in trying to put these folks at ease, explain why it is that the sentence is going to be imposed, that's where the court makes these references about the dark side and things of that nature, because he's trying to get them to understand that this individual that they know and love has committed a criminal act. No matter what we want to say about the way that the sentence was imposed, it is without question that this is a criminal act that he admitted guilt to. And that it is without question that in producing the materials that he used for his sexual gratification, crimes were committed. And so these are the factors that the judge considered, and that is the reason, I believe, for his lengthy statements. But as we say, we recognize that Barnhill controls in this case. We believe that it is distinguishable for the reasons I've mentioned. We believe that they considered the Imhoff report. We believe that he was speaking more extemporaneously to the audience members to try to explain why it is that their family member or friend would be going for this 20-year prison sentence. And we just asked the court to find that this is not fundamentally, or the imposition of this downward departure sentence is not fundamentally on the facts of this case. Thank you, Your Honors.
Right. Thank you. Mr. Delagrana, 5 minutes for rebuttal, sir.
Thank you, sir. The reality is, if anybody who represents a criminal defendant in a sex-type crime such as child pornography, and when you're looking at the potential of 112 years in prison, your only option in that case is sort of going to trial, which is very rarely done unless there's an issue with regards to a search, is to enter a plea and to consider or hope that the judge, if you argue mitigation, is going to give you a fair and impartial hearing and consider all the facts and circumstances that are presented. Otherwise, there'd really be no necessity for having downward departures or mitigation. In this particular case, as Judge Kazam readily pointed out, Judge Tharp has a preconceived idea with regards to anybody that's charged with this particular crime. That being that at some point in time, they have the potential to touch a child. And as a result of that, he's not willing, he's basically put on blinders when it comes to listening to testimony in the form of mitigation, witnesses that appear on behalf of the defendant. And based upon that, based upon his preconceived notion, he's not willing to listen or to all the facts and circumstances as to why that individual should get a lenient sentence. And based upon that, I ask that you reverse the sentence and remand it back for resentencing. Thank you.